Okay, I'm going to keep reading here in section B of the interpretive notes to the fatf 40 recommendations. And, it's kind of strange because I really wrote this Oh, okay. Obligations and decisions for financial institutions in DNFBB. Assessing risk. Financial institutions and DNFBPs should be required to take appropriate steps to identify and assess their money laundering and terrorist financing risks to customers, countries, or geographic areas, and product, services, transactions, or delivery channels. They should document those assessments in order to be able to demonstrate their basis, keep these assessments up to date, and have appropriate mechanisms to provide risk assessment information to competent authorities and SRBs. The nature and extent of any assessment of money laundering and terrorist financing risks should be appropriate to the nature and size of the business. Financial institutions and DNFBPs should always understand their money laundering and terrorist financing risks, but competent authorities or SRBs may determine that individual documented risk assessments are not required if the specific risks inherent to the sector are clearly identified and understood. Paragraph 9, risk management and mitigation. Financial institutions and DNFBPs should be required to have policies, controls, and procedures that enable them to manage and mitigate effectively the risks that have been identified either by the country or by the financial institution or DNFBP. They should be required to monitor the implementation of those controls and to enhance them as necessary. The policies, controls, and procedures should be approved by senior management, and measures taken to manage and mitigate the risks, whether higher or lower, should be consistent with national requirements and with guidance from competent authorities and SRBs. Higher risk. Where higher risks are identified, financial institutions and DNFBPs should be required to take enhanced measures to manage and mitigate the risks. Lower risk. Where low risks are identified, countries may allow financial institutions and DNFBPs to take simplified measures to manage and mitigate the risks. When assessing financial institutions and DNFBPs, should consider all the relevant risk factors before determining what is the level of overall risk and appropriate level of mitigation to be applied. Financial institutions and DNFBPs may differentiate the extent of measures depending on the type and level of risk for the various risk factors. Example, in a particular situation, they could apply normal CDD for customer acceptance measures, but enhance CDD for ongoing monitoring and vice versa. Interpretive note to recommendation 40, money laundering offense. We have, again, starting with paragraph 1. Countries should criminalize money laundering on the basis of the United Nations Convention Against Illicit Traffic in Narcotics, Drugs, and Psychotropic Substances. There are a lot of conventions. This one isn't one that's widely talked about, so I am going to write that down. Maybe keep a list of all of the conventions and take a look at their minutes or something. Couldn't find anything else to read. Convention against illicit traffic and narcotics, drugs. Traffic in narcotics, drugs. And psychotropic substances of 1988. A long time ago. That's called aka the Vienna Convention. And the Palermo Convention was in 2000. So let me just wait for this is Vienna. And then the UN Convention against transnational international organized crime of 2000, which was the Palermo Convention. Now, the reason why these conventions are important is because at that point in time in 1988, we first saw a group organize and say that money laundering should be criminalized, meaning that criminal offense. Countries should apply the crime of money laundering to all serious offenses with a view to including the widest range of predicate offenses. Predicate offenses may be described by reference to all offenses or to a threshold linked either to a category of serious offenses or to the penalty of imprisonment applicable to a predicate offense threshold approach or to a list of predicate offenses or a combination of these approaches. 3. Where countries apply a threshold approach, predicate offenses should at a minimum comprise all offenses that fall into the category of serious offenses under their national law, and should include offenses that are punishable by a maximum penalty of more than 1 year's imprisonment. Or, for those countries that have a minimum threshold for offenses in their legal system, predicate offenses should comprise all offenses that are punished by a minimum penalty of more than 6 months imprisonment. 4. Whichever approach is adopted, each country should, at a minimum, include a range of offenses within each of the designated categories of offenses. The offenses of money laundering should extend to any type of property regardless of its value that directly or indirectly represents the proceeds of crime. When proving that property is the proceeds of crime, it should not be necessary that a person be convicted of a predicate offense. 5. Predicate offenses for money laundering should extend to conduct that occurred in another country which constitutes an offense in that country and which would have constituted a predicate offense if had it occurred domestically. Countries may provide that the only prerequisite is that the conduct would have constituted a predicate offense and had it occurred domestically. 6. Countries may provide that the offense of money laundering does not apply to persons who committed the predicate offense where this is required by fundamental principles of their domestic law. 7. Countries should ensure that a. the intent and knowledge required to prove the offense of money laundering may be inferred from the objective factual circumstances. B. Effective, proportionate, and dissuasive criminal sanctions should apply to natural persons convicted of money laundering. And C. Criminal liability and sanctions, and where that is not possible due to fundamental principles of domestic law, civil or administrative liability and sanctions should apply to legal persons. This should not preclude parallel criminal, civil, or administrative proceedings with respect to legal persons in countries in which more than one form of liability is available. Such measures should be without prejudice to the criminal liability of natural persons. All sanctions should be effective, proportionate, and dissuasive. There should be appropriate ancillary offenses to the offense of money laundering, including participation in, association with, or conspiracy to commit, attempts, aiding and abetting, facilitating and counseling the commission unless this is not permitted by fundamental principles of domestic law. We are at page 36. There's an interpretive note to recommendations 4 and 38, confiscation of provisional measures. Countries should establish mechanisms that will enable their competent authorities to effectively manage and, when necessary, dispose of property that is frozen or seized or has been confiscated. These mechanisms should be applicable both in the context of domestic proceedings and pursuant to requests by foreign countries. Interpretive note to recommendation 5, terrorist financing. Terrorist financing offenses should extend to any person who locally provides or collects funds by any means, directly or indirectly, with the unlawful intention that they should be used, or in knowledge that they are to be used in full or in part, A. to carry out a terrorist act or acts, B. by a terrorist organization, or C. by an individual terrorist. 3. Criminalizing terrorist financing solely on the basis of aiding and abetting attempt or conspiracy is not sufficient to comply with the recommendation. Terrorist financing offenses should extend to any funds, whether from a legitimate or illegitimate source. 5. Terrorist financing sources should not require that the funds A were actually used to carry out or attempt a terrorist act, or B be linked to a specific terrorist act. 6. Countries should ensure that the intent and knowledge required to approve the offense of terrorism financing may be inferred from objective factual circumstances. 7. Effective, proportionate, and dissuasive criminal sanctions should apply to natural persons convicted of terrorist financing. 8. Criminal liability and sanctions, and where that is not possible due to fundamental principles of domestic law, civil, or administrative liability and sanctions, should apply to legal persons. This should not preclude parallel criminal, civil, or administrative proceedings with respect to legal persons in countries in which more than one form of liability is available. Such measures should be without prejudice to criminal liability of natural persons. All sanctions should be effective, proportionate, and dissuasive. 9. It should also be an offense to attempt to commit a offense of terrorist financing. 10. It should also be an offense to engage in any of the following types of conduct. A. Participating in it as an accomplice in an offense as set forth in paragraph 2 or 9 of this interpreted note. B. Organizing or directing others to commit an offense as set forth in paragraphs 2 or 9 of this interpreted note. And C. Contributing to the commission of one or more offenses as set forth in paragraphs 2 or 9 of this interpreted note by a group of persons acting for the common purpose. Such contribution shall be intentional and shall either I. be made with the aim of furthering the criminal activity or criminal purpose of the group, where such activity or purpose involves the commission of terrorism financing offense, or 2. be made in the knowledge of the intention of the group to commit a terrorist financing offense. 11. Terrorist financing offenses should apply regardless of whether the person alleged to have committed the offense is in the same country or a different country from the one in which terrorists or terrorist organizations associated with terrorist acts occurred or will occur. Interpretive note to recommendation 6. Can I skip the I think it did. This is recommendation 6. I wanted to add an interpretive note to. Come on, get back to it. Yes. Objective. Recommendation 6 requires each country to implement targeted financial sanctions to comply with the United Nations Security Council resolutions. Require countries to freeze without delay the funds or other assets, and to ensure that no funds or other assets were made available to or for the benefit of any person or entity designated by the United Nations Security Council or Security Council under Chapter 7 of the Charter of the United Nations, as required by Security Council Resolution 1267 in 1999 and its successor resolutions, or 2. Any person or entity designated by that country pursuant to the Security Council Resolution 1373 of 2001. 2. It should be stressed that none of the obligations of Recommendation 6 is intended to replace other measures or obligations that may already be in place for dealing with funds or other assets in the context of a criminal, civil, and administrative investigation or proceeding, as is required by Recommendation 4, confiscation of provisional measures. Measures under Recommendation 6 may, implement criminal proceedings against a designated person or entity and be adopted by a competent authority or in a court, but are not conditional upon the existence of such proceedings. Instead, the focus of 6 is on the preventative measures that are necessary and unique in the context of stopping the flow of funds or other assets, terrorist groups, and the use of funds or other assets by terrorist groups, and determining limits of fostering widespread support for an effective counter-terrorist financing regime. Countries must also respect human rights, respect the rule of law, and recognize the right